What's up, y'all? This is Joel Solides under the color of law again. I'm talking to my brother and about Candace Owens and stuff. I really like Candace Owens. I believe she's doing a lot of good things for our people, and I love the way she talks. You know, her information is dead on, and the way she sees things is dead on. You know, however, I don't really get into that, but what pisses me off the most is our ignorance as a people. Like, we got to stop being ignorant. I know every time you see something done with the police, that does not mean all the time that the police are always wrong. You know what I mean? Look at the full picture. It's like glass half empty, glass half full. That's what it's like. Well, how do you see it? Is that glass half empty or is that glass half full? Yeah, I mean, look at the full picture and see what's going on. I mean, be optimistic, man. What you're thinking. It's not that hard. Everything is not racial profiling. I'm tired of that word. I really am. I'm tired of people saying racial profiling. Okay, I'm tired of people saying if it's a white person that had never been done. Like, oh my God, I'm tired of hearing that. You know, my family just posted a video about some stuff like that, and a white guy, he had a gun, and it was licensed, but he let him know, this is my Second Amendment rights. I'm allowed to carry a firearm. I do not have a concealed permit. He had an open carry one. Now, granted, yes, it might have went different. However, I'm a firm believer in law, in justice. I'm a firm believer in it. It works if you know what you're doing. It works. Learn your rights. When they pull you over, all you have to say is, at this moment, I am demonstrating specifically my Fourth Amendment right to be secure in my person's papers and effects against unreasonable searches and seizures. All you got to say. That's it. That's it. And from that moment on, if the officer chooses to still violate your rights, he is then no longer, and I said this before, he is then no longer protected by the color of law. They have something called the good faith doctrine. He's no longer in good faith. Like, they in good faith, that basically allows him to go ahead and violate your rights, as long as they had some type of legal standing to do so. Basically, you know. In other words, it wasn't their intentions to do so. They didn't know they were violating your rights. They were just doing their job. That's like kind of good faith. Matter of fact, I'm gonna give you the exact definition for it. Give me 1 second. Instead of just going ahead and spitballing it from what I know about it. Oh, my ankle. I broke my ankle, y'all. Oh, I can't wait till it heals. I got my Black Law Dictionary out. This is ridiculous. We got to stop that stuff, man. Got to stop. E, F, G. Just keep yelling and pumping fists. Like, man, stop that. Makes no sense. Let me see if it's in. I hope it's in here. Let's see. Good faith exception, they're calling it in here. Criminal procedure, an exception to the exclusionary rule, whereby evidence obtained and this has to do whenever the criminal proceedings take place. Rule whereby evidence obtained under a warrant later found to be inviolate. You know, in other words, they had a legal standing to violate your rights. That's basically what I'm saying. Yeah, I mean, at first. You know, at first they did it right, but they did it wrong. So it's kind of like a gray area with them. You know, that's what the good faith exception is. It's a rule whereby evidence obtained under a warrant later found to be invalid. In other words, the warrant wasn't even no good to be signed to begin with. That's what they're saying. Like it was. They had some type of legal standing. Like this shit, it gets deep. So the judge might sign a warrant because the judge can sign a warrant. He can sign a warrant that is not constitutionally strong. However, the officer shows that he went about the proper procedural steps to go ahead and get the warrant signed so your rights can then be not violated, but, you know, taken away because they believe you're involved in some type of criminal activity. You know, and Terry versus Ohio, Justice Douglas, he speaks very, very clearly on what the proper procedural steps are when it comes to executing a warrant and or getting probable cause from a local judicial magistrate. You know, and I have it written down here, so I'm gonna find it for y'all and tell y'all exactly what Justice Douglas says. It's very, very very powerful on what he says. Give me 1 second. I'm trying to hurry up because I don't want to hold up too long. I'm already on 7 minutes. Carroll versus the United States. I know I highlighted it. Okay, Justice Douglas dissenting in Terry versus Ohio. He says, I agree that the petitioner was seized within the meaning of the Fourth Amendment. I also agree that frisking the petitioner and his companions for guns was a search. Right, okay. So they were seized and then they were searched. He said, but it is a mystery. It's a mystery how that search and seizure can be constitutional by Fourth Amendment standards unless there was probable cause. 1, to believe that a crime has been committed. 2, a crime was in the process of being committed. Or 3, a crime was about to be committed. Read that again. He said 1, to believe that a crime had been committed. Or 2, a crime was in the process of being committed. Or 3, a crime was about to be committed. So let me break this down. What he means by this. Okay, let's go to the first one. To believe that the crime had been committed. So in other words, let's say a homicide took place. Okay, they're investigating the homicide. After they get whatever information outside of them comes in, then they go and corroborate with their own information and their investigative, details that they had gathered throughout the case, and take that information corroborated with their own, put it in the body of an affidavit of probable cause, submit it to a judge, let the judge sign it. That is, he has probable cause to believe that a crime had been committed. The second one, a crime was in the process of being committed. For example, let's say a crack house, a drug house, the Carter, for example, say the Carter. They believe that this building is packaging up and selling an X amount of heroin or cocaine or whatever at this time on this date. This is what they believe. This is the process. We believe people are doing this at this moment. They believe this process is being taken place. They're buying the drugs, they're bringing the drugs to this place, they're packaging the drugs and selling the drugs. This is in the process. This is the process that this crime is being committed. That's what they're saying. Or a crime is about to be committed. So now I'm gonna use the same thing twice. All right. First of all, you got manufacturing. Whenever they're taking it and they're buying it and they're packaging it up, and then now the crime is about to be committed. Then the selling of the narcotic. You understand what I'm saying? after they done packaged it up and all that, now they're about to go and sell the narcotic out of the building. They leave the building, put it in the bag, however they're transporting it. This crime is about to be committed. You understand what I'm saying? That's basically how that works. I mean, that's how they would go get information and then they would go submit it to a judge. That's how that works. Like, not that hard. Now, probable cause is hard to find for the officers, but man, y'all got to learn this stuff so you can know what to do when you get pulled over. It's simple. Learn it. I had to get into that because that was like, and even in this case, man, the DA in here, he said some crazy stuff. Like, he said, I had it highlighted, and then the judges, they had to help him. They basically, now, Mr. Terry, he lost the case. He shouldn't have lost it, but he lost the case because he didn't make the correct claim. He challenged the wrong thing. He challenged the gun instead of challenging the information that led to the seizure of the gun. That's why he lost. He suppressed the gun. Now, if he would have suppressed the information that they gathered that enabled them to seize him first before they seized the gun, then he'd have won. What comes first, the chicken or the egg? He just wanted to seize the gun. He jumped over all the information and or evidence that they had that allowed them to seize the gun. They have to seize you first before they seize the evidence. And in order to seize your person out of society, they need other evidence on why this person they should no longer have their constitutional civil rights, why they should be stripped from them. That's it. That's how that works. Let me see what he said. On this says on the motion to suppress the guns, the prosecution took the position. The prosecution took the position that they had been seized. The guns have been seized incident to a lawful arrest. This is what this dummy says. The prosecution took the position. The prosecution took the position that the guns have been seized incident to a lawful arrest. Oh my Lord. The trial court responded. They rejected this theory, stating that it would be stretching the facts beyond reasonable comprehension to find that Officer McFadden had probable cause to arrest the men before he patted them down for weapons. This is what they said. That's what the trial court said. It's right here. How can I turn this camera around? I don't even know how to do this. Hold on.